This is Barry Zalma speaking for Claims School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why arguments, especially made in court, are not facts. Only evidence can prove facts in a court of law. And charging less for a product does not disparage a competitor's product, thus providing coverage for an insured. CTzumi Electronics LLC appealed from a judgment of the United States District Court for the Southern District of New York, granting summary judgment in favor of the Burlington Insurance Company and denying Tzumi's motion for partial summary judgment. Tzumi sought a declaratory judgment that a commercial general liability policy required Burlington to defend and indemnify Tzumi in an underlying consumer class action lawsuit, alleging that Tzumi misrepresented the charging capacity of certain power bank devices that it sold. Burlington denied coverage because the complaint against Tzumi did not allege disparagement of any of Tzumi's competitors. It only disparaged Tzumi itself. In Tzumi Electronics versus Burlington, the United States Court of Appeal for the Second Circuit on December 18, 2024, affirmed the United States District Court. The dispute was whether the underlying consumer action against Tzumi fell within the insurance policy's coverage of claims for personal and advertising injury, defined in relevant part to encompass claims, quote, arising out of publication in any manner of material that disparages a person or organization's goods, products, or services. Tzumi interpreted the allegations in the complaint as alleging that Tzumi implicitly asserted that its power products were of significantly higher value, but at a lower price than similar products of its competitors, implicitly negatively comparing competing products, implying that the competitors' products were overpriced in an attempt to bring the allegations in the suit into a covered risk of loss. The Second Circuit noted that the underlying complaint contained merely a passing citation to the entirety of California false advertising statutes as part of a larger list of general citations to the consumer protection statutes of 11 states. The misrepresentations at issue did not include any assertion that reflected on competitor products and thus cannot support a claim of disparagement. The Second Circuit concluded that Tzumi's allegations shed no light on the actual substance of the underlying complaint, only its own interpretation of that complaint. The Second Circuit agreed with the insurer and the district court that Tzumi failed to raise a genuine dispute of material fact as to whether the consumer action fell within the insurance policy's coverage of claims for personal and advertising injury. The district court correctly determined that there is no possible factual or legal basis on which the insurer Burlington might eventually be obligated to indemnify Tzumi under the policy provisions. In my opinion, how an insured interprets a policy is not a fact, material, or even weak. Argument does not establish that Tzumi had disparaged its competitors' products. If a manufacturer could get coverage for disparagement by simply selling a similar product at a lower price, every low-priced product, whether a battery or an automobile or a charging station, would defeat the intent of the insurance. Insurance is required to provide defense and indemnity only for contingent, unknown, or fortuitous events. Setting a price lower than that of the competitors is not a fortuitous event. It is an intentional action of the manufacturer. So there was simply no coverage available for Tzumi. This video is adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to all 4,950 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.